Ladies and gentlemen, welcome again to the 23rd Annual Hybrid Conference. My name is Lerato Rignello. For those that don't know me, I would like to introduce our next speakers that are going to be speaking about the pitfalls and practicalities in building labor relations in the context of community grievances. The first specializes in employment law, with particular focus on occupational health safety law. He has acted for a broad range of employers in the employment tribunal and courts. He has also advised and acted for a variety of leading mines, construction, and engineering corporations in investigating and inquiries pertaining to occupational health and safety. One of the people that's on a panel as well has experience in prosecuting hearings, drafting pleadings, applications to the Labor Court and Labor Appeal Court. He also drafts employment contracts, conducts due diligence investigations, and provides advice on restraints of trade. That being Mr. Dumisani has litigation experience and has appeared in the Labor Court and Magistrate Court and the Commission of Conciliation, Mediation, and Arbitration. Ladies and gentlemen, please help me welcome Mr. Kenneth Coaster and Dumisani Ndiweni.
Thank you very much, Lerato. Good afternoon, ladies and gentlemen. So the first thing is that despite being lawyers and thinking we know everything, we are not sociologists, and I just want to put that out there in relation to the topic that we are talking today about building labor relations in the context of community grievances. In what we would like to do this afternoon is to discuss and share with you some of the practicalities and the issues that have arisen in our practice in reality in relation to how we deal with these community grievances. Because it appears to us that over the last number of years that community involvement in employer-related environments has escalated to, and so we also want to clarify to say that we are in no way intending to be controversial. What we are looking at is a real life. Dumisani and I are looking at examples of what it is that some of our clients have faced, and so it is essentially a legal look at this topic and not necessarily on sociological principles. So let's just begin with a very thin slice of the problem, and the very thin slice of the problem from a mining community's point of view is that there is legislation, in this case the Mineral and Petroleum Resources Development Act, which has in its preamble some very interesting, some very clear thoughts as to how a community might see a neighboring or an employer which sources labor from the local community. The first thing, of course, is that communities, I think, more and more are very aware of the fact that they have one bite at the cherry. The MPRDA says that the minerals and petroleum resources in South Africa are non-renewable natural resources. And of course, with that, everybody understands, and specifically the communities understand, that in the event that they don't participate or be seen to be participating right from the outset in a new venture, that it's going to be harder and harder for them to get access thereto. Secondly, the MPRDA says our natural resources belong to the nation, and that the state is the custodian thereof. So there is definitely, from a purely statutory point of view, the MPRDA indicates to mining communities that the wealth which is situated in situ, it belongs to all of us. And then, of course, another aspect of the MPRDA, which is contained in the preamble, is recognizing local and rural development and the social upliftment of communities. So, without going into the sociological aspects, that is a very valid view for a community to hold in relation to its what legislatively it might be able to enjoy from. You take us through what it's like from the mining company's point of view.
So Ken, from a mining perspective, the MPRDA focuses on guaranteeing security of tenure for businesses. And it also emphasizes on creating an environment that allows businesses to be competitive and efficient. So what that means is that the MPRD caters for the long-lasting relationship of the business through its mining projects and operations. The MPRD as well on its side creates a very broad sense of operation, because it caters for both the mining and the communities. And most importantly, what it does is it tries to strike a balance between the two interests.
I mean, I agree with you, and I think one of the very important themes to bear in mind in our discussion this afternoon is that the community are the employees, and the employees are members of the community. There's a great intertwinement between these two, let's call them sectors, between the community and employees. And that is what makes, I think, the management thereof, especially in relation to employers, quite difficult. Because, Dumisani, as you'll agree with me, we've seen some horrors about what happens when poor community and employer relationships go awry.
Definitely, Ken. I mean, what we need to appreciate, and businesses particularly need to appreciate, is that they operate within the space of a community. They are part and parcel of a community, and therefore there needs to be a relationship between the ordinary citizens of a particular community and the businesses at hand. What causes unrest and what causes, as you see in the image there, what I would refer to as the aggrieved neighbors, which are the ordinary community members, is that there is a lack of job opportunities for members of the community. You have a situation where businesses and companies are not engaging in social development of the surroundings of the community. And the last one I would like to categorize as politics. The politics of the community. Such example would be one where former employees or current employees want to get their needs addressed by the companies and the businesses. So they would mobilize the communities to ensure that they disrupt business operations to have their concerns aired and heard and addressed.
And unfortunately, it seems also that as the labor, and I know we're talking now about community involvement in relation to its interaction with employers, but in relation to straight employer-employee relationships, unfortunately, acts of violence have proven to be quite an effective tool. I mean, if we just have a look as far back as 2010, Judge Basson of the Labour Court talks about, she says, in summary, this strike was marred with the most atrocious acts of violence on non-striking employees. The individuals who perpetrated these acts had no respect for human life, the property of others, or the rule of law. What makes matters worse is the fact that it appears from the evidence that the police and criminal justice system have dismally failed these defenseless non-strikers. It must be pointed out that although a certain measure of rowdiness and boisterous behavior is expected, all-out sort of violence, and as she says, senseless violence has just gone way beyond the pale. And so it's in this context that we could substitute for employees the community. I don't know if you agree on that point.
Right, now where the community has engaged in protest, which has undoubtedly affected the operations of a particular business, and therefore the business cannot operate whilst the community is protesting. And the question is, what does the business do?
Correct. I mean, I think the one of the messages that, of course, needs to come across at this stage, because it might seem quite one-sided, is, of course, we must move away from a model of reactive addressing of community protests. Employers need to be proactive. Trade unions need to understand their role in relation to be as patient as possible, understanding that no business necessarily wishes any harm on them or to deprive them of the access to the capital which they might have. So perhaps you can take us through what we've discovered in a matter where
between the employer and the employees. The normal course would follow, where you would go to the CCMA conciliation and the labor court would then enjoy jurisdiction. But when it comes to communities, it's a bit of a complicated one. You need to understand that the mindsets of the individuals you are dealing with are of individuals who don't necessarily appreciate are giving rise to the unrest within the community. So generally what should happen is that businesses should engage with the community leadership. The problem you have with that is identifying who the legitimate leadership is, because you would be engaging with a particular group of leadership, and before you know it, there's a splinter group, and at the end of the day, you are actually engaging with the wrong leadership. So you need to identify who the correct leadership is, engage the local municipality, amicable for both parties. Then obviously you are now put into a situation where you'll have to try and interdict this process. And interdicting that would have to go through the High Court, because the High Court would enjoy jurisdiction in that particular aspect. The problem you have, sorry Ken, the problem you have over this is when you have a scenario where you had erstwhile employees, they were previously in your employ, they are no longer in your employ, and they've moved back into the definition of community, and they now engage in protest action. That's what then happens.
So this is the part of that knowledge that we'd like to share with you today, in that we've seen matters where it occurs in the context of a Section 189 capital A process. The employees are they go through the 60-day consultation period, sometimes with a facilitator, sometimes without, but more often than not with a facilitator. And right at the end, after the 60 days, the employer then notifies its employees of a notice of termination after the 60 days. And then the employees, together with their trade union, follow a legitimate process to embark upon industrial action for the balance of their notice period. And so this is where it gets difficult, I guess. And again, I say this in the context of we're not looking to go to court, and of course those other measures of engaging with the community should be happening way ahead of this. But when you are faced with a situation, you're preparing papers to go to the Labour Court in relation to applying for an interdict because it relates to the employment relationship of the individuals. And after the 30 days, in this case, the individuals, the erstwhile employees continued with their protest action. In that context, you have to change fora very quickly, because it's not possible. We've now moved away from this being an employment dispute to it being a community dispute. The other aspect, I think, that makes this very difficult is in relation to whether or not other aggrieved members of the community support employees who may be embarking in protected industrial action. What you might do is perhaps during the 30-day period that the employees are still employees working their notice or embarking upon industrial action, which industrial action is protected, that they are supported and joined by groups of community members who have other agendas. And so now you face this very difficult legal battle in terms of how are we going to actually deal with this in a sensible fashion. For instance, if there were to be misconduct during the industrial action, which happens during the 30-day period, for which you could legitimately obtain an interdict, in the context that you go to the labor court, because the employees are still employees, you would need to identify the persons. But what do you do? What is the effect of a court order in relation to members of the community who are not in that context of they're not employees, they're simply members of the community? And it's in this case that employers really need to manage and be alive to many of the factors that they might have to do. I mean, one of the things that we've seen is that after the 30-day period, which has expired in the of the notice period in the Section 189 capital A process, we've seen is difficult to manage. And in fact, the employers themselves are very confused, because what they did do in certain circumstances is they agreed to picketing rules. And so the employer is now engaging with the community after the 30-day period, trying to enforce picketing rules in relation to employees, to persons who are no longer their employees. So critically missing in all of this, we develop a proactive type of regime so that we can avoid having escalation of frustration and conflict.
We must appreciate as well that South Africa is a country where protest action is something that is the norm. And in order for us to actually regulate this type of action, it will be regulated in the Gatherings Act. Gathering is defined as an assembly of more than 15 people in a public place or premises wholly. What we need to look at is particularly the B is groups to hand over petitions or to mobilize and demonstrate support for oppositions to the views, principles, and policies. So in this particular instances, the public can gather, and it's permitted within South Africa. What role does the police play hand in hand with the business in order to ensure that the gathering doesn't, one, create damage to property, injure individuals, or even cause death? And in that particular instance, we still have to consider the Gatherings Act and how the Gatherings Act and the services rendered by the police service all interact with business as well.
So just going back to that earlier quote by Judge Basson, where she effectively says, well, the law enforcement authorities failed dismally in that case to protect non-striking employees. Let's extend that to look at the context of the community solely protesting at a specific workplace without any employee involvement and intimidating and or threatening employees who wish to continue work and in fact have no qualm in relation to the community's specific grievance. And this is something that we have seen that is missing, and it really relates to involving local authorities and specifically the South African Police Service in a constructive, proactive way. Again, please, it's important that there's nothing, we do not want escalation, but the Gatherings Act does allow certain aspects of the police's involvement to be, it gives them a certain amount of authority. Our experience has been that the police, when we sit with a situation where there is community protest, where a community perhaps has unlawfully blockaded a mine or a workplace, that the police do have a role, but the police say to our clients, unless you provide me with a court order, I'm not going to do it. So has got two real aspects. The first thing is that it talks about what the South African Police Service is able to do before the gathering. So you'll see it says the SAPS is required to participate in negotiations resulting from any proposed protester action. So that's, again, being proactive before the time. And the authorized member is then entitled to be present at any meeting. This is the SAPS member, B of the Gatherings Act, in order to discuss the implications, impositions, and conditions upon the gathering. But Section 9, Dumisani, goes further, and we talk about what can the police actually do. Do you want to take us through that?
So just quickly, if the police come across a scenario where they realize that there is the potential for serious injury to individuals, damage to property, or even the likelihood that somebody might be killed, the police at this stage can react with the appropriate force deemed necessary to curtail this. So there is this perception that the police don't do enough when there is community protests. But we need to understand that the police, to a certain extent, are limited in terms of what they can do and what stage the protest is at. But what we think as solutions, which we move over to now to practical solutions, is I'd like to summarize it as intelligence. Businesses need to have community intelligence. Businesses need to appreciate that they operate within a community and they need to gather as much information as possible. There is further no point in gathering information if there is no system in terms of how we store this information and how we then take this information and create and find solutions rather. So one of the most effective ways is to ensure that you have individuals who go out and engage with the community. Go out and engage with the community meaningfully, not just as a mere exercise, tick box exercise, but engage with the community meaningfully. And you need to also have a scenario where the community feels that they are being heard. Don't just brush their concerns aside. Brewing. That's when you have a duty and responsibility to be proactive, because the failure of being proactive will result in protest action which will halt your business. Can you have any further on that?
I think, just in summary, that employers, and again, must be proactive, deal with the community issues and grievances proactively. Don't let it get to a stage where there is a wildcat, can call it that, at the premises, and one is caught in a very difficult position. The need for a mandamus, is there really a need to go to court to say to the police, restore law and order? We would propose that in that respect there isn't. So I think, I don't think it's, I think that in relation to community protests, what we do need to see is local authorities, including local government, as well as the South African Police Service, playing a more integral, proactive role rather than reactive, because what we do see in those circumstances is benefits to both the employer and the employees. Unless there's anything else, Lerato, thank you very much. We're happy to take any questions.
Thank you very much for a very detailed and insightful presentation. I'm just going to open the floor for any questions. Please make it brief, as I've specified. There is a SASLAW app for you to email more detailed question and for them to elaborate further. Are there any questions? Yes, ma'am. If you will allow me to be the runner for you. There you go. Thank you.
Thank you. Mr. Costa, you said trade unions need to understand their role in communities. My question is not really related to what you were saying, but considering that government derives its funds from taxpayers, is it legally and morally correct to prioritize? I mean, as you all know, we've got a problem. There's an impasse with the public servants, and what is happening out there in the public service, the salaries. Now, what I would like to know, is it legally and morally correct to prioritize and honor collective agreements on salary increases rather than to prioritize services to communities or citizens, which is the sole reason for the existence of government? Thank you.
Over to you.
Thank you. So thank you very much for that question. It's quite a difficult question. And as I said earlier, I'm not a sociologist. At the end of the day, I think purely from a legal point of view, we need to understand that what we've got is we've got legislation to actually put everybody under that umbrella is a very difficult thing to do. I think at the end of the day, the model that we've got, of course, is one of, as I was listening to Mr. Vavi speak earlier, neoliberalism. It is that is the model within which, of course, trade unions and the role that trade unions play is very important. I often say to our clients, especially international companies who inquire about, what are the rights of trade unions in South Africa, we say, building a good relationship with the trade union is much more business. It has a far greater business efficacy than not building such a relationship. So at the end of the day, I do believe that the role that trade unions play must be balanced, because remember, trade unions will represent employees, and we must not lose sight of that, because I think very often it might be that a specific group of people or a specific trade union is actually advancing the role of the community. And again, I'm saying this is a very difficult issue, because the community, whilst of course the community might have a very valid grievance, there are other avenues open to communities in relation to the structures that are set up in the social and labor plans of a specific, and I'm talking now specifically a mining community, which allows trade unions derive their mandate from the workers. They need to ensure that they do not conflate that mandate with the that they do not conflate that with that of the community. I hope I've answered your question. As I say, it's a difficult one.
Did you want to add something just quickly, Dumisani?
No, look, ideally you want a situation where the public sector is catering, is performing at an optimal level. We unfortunately don't live in that type of country. And the agreement, when you speak about collective agreements between employees and business, and you've got then to keep in mind that there's also a social agreement, a social pact between the communities and government. So what you want in an ideal situation, which is we're not going to get in
For your time. As a token of our appreciation, would like to provide these to you. All social COVID regulation protocol observed. Thank you very much.
Thank you.